Hello everyone, it's Mark and welcome back. In this video I'm going to talk to you about the advantage of agreeing to sign as a conditional voluntary patient. I'm also going to talk to you about the disadvantage both under Section 12 and the Baker Act. I'm going to read you some information here from the statute here in Massachusetts, and I'll be honest with you, I respectfully disagree with what's written down here, but okay, I'm going to share the law with you anyway. By pursuing conditional voluntary admission status, an individual prevents the facility from being able to pursue court-ordered commitment. Why you would ever prevent them from doing that is beyond me. Frankly, if they want to keep me, let them go get a court order. The facility is also prevented from pursuing a district court order authorizing the administration of antipsychotic medication, although the facility could seek a comparable order in probate court, meaning in Massachusetts they need a court order to basically forcibly medicate you. I can tell you from practical experience, at least here in Florida, it doesn't seem to deter them one bit that they may or may not need a court order. They just simply, if you don't take the meds, they're going to turn you over, hold you down, and they're going to stick a big needle in you, and they're going to medicate you anyway. In addition, an individual on conditional voluntary status has the ability to sign a 3-day notice of the intention to leave the facility. The notice forces the staff to act, either to allow the patient to leave or petition for commitment. You know what? You're right. If you revoke consent, it's going to force them to go to court. And I would never, ever counsel any client ever to agree to stay on a voluntary basis. And here's why, and I'm going to read this again from the statute here in Massachusetts. By signing a conditional voluntary admission, an individual forfeits certain rights. An individual waives the right to a hearing before a judge to determine whether you meet the legal standard for involuntary commitment. Here, one regains the right by signing a 3-day notice. An individual waives the right, in some situations, to certain guarantees of the federal Constitution: right to safety, right to adequate treatment, and freedom from harm and under restraint. However, the facility may be compelled to provide these rights under the state constitution. Okay, let me sum this up, because this is all sort of legal jumbo and mumbo jumbo. Both under Section 12 in Massachusetts and under Florida law, you can agree to stay on a voluntary admission basis. And what typically happens is the facility basically threatens the person that if they don't agree to stay on a voluntary basis, they're going to get a court order. And I have no problem with that. If the facility thinks you meet criteria, let them go and prove their case. Let the state establish before a judge that you actually meet legal criteria. And so I routinely talk to clients, and I've spoken about it publicly. There is absolutely no reason why you would ever agree to be on a voluntary admission basis, either in Massachusetts or Florida. If the state wants to detain you, you have a right to due process, the right to counsel, the right to cross-examine, the right to be heard, the right to remain silent, all of those things that are guaranteed to you, okay? I would never, ever agree to stay on a voluntary basis. But hey, the statutes in Florida and Massachusetts provide for it, and I'm sharing the information with you. Do with it what you may. Anyway, thanks for tuning in. See you in the next video. Bye-bye.